police brutality does exist, and आपने तो बहुत केसेस लड़े हैं for people who have faced police brutality. One such incident I would like to share with you. तो एक couple है, मेरे friends है, तो they are married and they went for a drive in a tier 3 town. I wouldn't name the city or the couple. They were driving and a police car stopped by. So the guy got out for a smoke and the police car stopped. उसको पूरा चेक किया, उसकी जेब चेक करी, गाड़ी चेक करी, without any probable cause. They were not mentioning it. दो फीमेल पुलिस नहीं था तो the female was not harassed, but I'm sure they were capable of it. And somehow the female got a hold of his phone. She called me. मैं वहाँ पहुँचा. फिर I called a lawyer. उन्होंने उनके सीनियर से बात करी because lawyer had a touch with the SI there. And then those three were suspended and everything was done. But मुझे अगर फ़ोन नहीं करता, ये कपल के पास ऐसा कोई आदमी नहीं होता या ऐसा कोई लॉयर नहीं होता, तो अगेन कमिंग कि पुलिस ये तो मेरा क्वेश्चन ये है कि ये पूरा सीन में लीगल इलीगल पे हम बात करना चाहते हैं कि क्या मेरे दोस्त लीगल थे? गाड़ी से निकल के सिगरेट पीना, रात में ड्राइव पे जाना, अराउंड 2 बजे का समय था. क्या पुलिस लीगल साइड पे था? वॉज हिज प्रोसेस लीगल वेयर ही चेक्ड without any probable cause, without any document, without the presence of any lawyer? Or third, what legal steps can someone take? कि अगर ये हो गया है तो एक लॉयर के पास जाने के बाद इस चीज पे ऐसा क्या कर सके कि कम से कम वो 3 पुलिस वाले आगे ये गलती ना करें. तो दिस इज माय क्वेश्चन कि पुलिस लीगल थी या इलीगल थे? मेरे दोस्त जो काम कर रहे थे वो लीगल था या इलीगल था? एंड क्या स्टेप्स ले सकते हैं एज द विक्टिम सो दैट कोई और आदमी इस चीज का विक्टिम ना बने?
See, as a reasonable suspicion, if there is a reasonable suspicion that exists, then the police can stop you and search your vehicle.
Okay.
There is no stopping.
ये law exist करता है.
There is, if there is suspicion, if there is some suspicious activity that the police may see, then on suspicion it can definitely check your documents and things like that. But it can definitely not arrest you. अगर वो बिना कोई पुख्ता सबूत के या किसी चीज के आपको अरेस्ट करता है, then definitely it is police brutality.
And then जेब चेक करना, ये सब करना is also a part of the suspicion process?
No, the जेब चेक करना, as far as जेब चेक करना is concerned, the police can ask the person himself to do it.
Okay, but they don't have the right to.
They don't have the right to touch you. Okay. Directly, without any apprehension. And I think what the example that you gave, that he stepped out for a smoke. Ideally, the police should not have. But if there is any suspicious activity that they may have thought is existing at that point of time, and they can stop a vehicle and check. Coming back to the steps that you can take. If there is brutality, if there is, suppose there is an arrest and if you have wrongly been arrested, then as far as Delhi is concerned, there is Delhi Police Punishment and Appellate Rules, which govern for such erring police officers. You can make a complaint to the Delhi police and then an inquiry can be initiated. And if there is an illegal arrest, because arrest पे भी अभी बहुत सारे guidelines आ चुके हैं. There is Arnesh Kumar versus State of Bihar, which was a landmark judgment by the Supreme Court in 2014. Then there is Satyendra Kumar Until versus the Central Bureau of Investigations. There are multiple other judgments that are being passed by different high courts, by the Supreme Court. So the police can always be taken into task. And in fact, if I'm not wrong, there was one judgment by a division bench, which means a 2-judge bench of the Delhi High Court, which also gave guidelines that if there is an illegal arrest of any kind, then you can also file an FIR for wrongful confinement against those police officers. I think it was, pardon me if I'm not able to remember the correct name, but I think Sanjay Kumar versus State of NCT of Delhi. That was the judgment. It was a division bench judgment authored by Honorable Justice then Dr. Murlidhar, and it was a wonderful judgment in which in a similar situation a person was arrested from UP without taking the consent of the or without producing him before the magistrate in that particular place in
Okay.
UP. And they were taken into task, or maybe vice versa. I think the person was arrested from Delhi, but the UP police had come to arrest that person in Delhi, and without producing him before the concerned magistrate, which is a mandatory provision when there is an interstate arrest, that person was taken into custody. So in that situation, the court reprimanded. The court also said that contempt can be initiated against such police officers. I am fighting such contempt cases against few erring Delhi police officers on a similar battlefield like what I mentioned in this particular case.
Right.
My client was picked up from in Uttar Pradesh by the Delhi police without him being produced before the concerned local magistrate, without informing the local police there, for an offense which was less than 7 years, without serving him a notice under section 41A of the CRPC, or currently under the BNSS, it is 35 subsection 3 of the BNSS. That person was picked up and brought to a police station in Delhi. And I have filed a contempt. The court has initiated action. The initial action has been taken, and it is pending for the final arguments. So there are a lot of remedies which a person may exercise. Similarly, in one of the cases, there was a complaint that was made under the Delhi Police Punishment and Appellate Rules, and the rules provide that if there is a complaint that is made, then there has to be a preliminary inquiry by authority who has to be above the rank of the person who has been alleged in the particular offense. So if suppose the person who has committed that offense, the police officer, is a sub-inspector, then the inquiry officer has to be someone above the rank of that sub-inspector. So this is one of the norms that needs to be followed. And without following those mandatory requirements, an inquiry was conducted. My client was never called to record her statement before the police, and an order was passed.
It was a her.
It was the client is a female, yes, and the order was passed, and now we have filed a writ petition before the High Court of the Delhi High Court. So there are different ways wherein you can always speak for your rights and approach the courts and bring to the knowledge of the court such police brutality. So, and in fact, there are many landmark cases to this as far as police brutality is concerned. And there are numerous guidelines given by the Supreme Court, by different high courts.
Okay.
Yes.